First paragraph. Come to para, page 12, internet page 12. We have also looked to the counter affidavit, a state which was emphatically read over by Sri P.K. Sahi. We queried the Learning Council to have our uploaded question number so and so after examining the comments to result the examination result being cancelled. Because this, his reply, the Commission of Inquiry was satisfied they could have been answered, circulated to a specific candidate code, mobile phones, and although mobile phones were prohibited inside the examination room. Here could be instances where candidates had smuggled the such instrument. Hence, to maintain transparency and ensure credibility of conduct of the first session so and so was cancelled and retest conduct. Candidates who did not have the benefit of our being I will supply the answer. Since it could not only be occurred and after examination concluded. Now after this, please come to para 16. Para 16. Para 16. The Commission has lodged FIR economic offences, but here they did not. And of which annexure C, the report of the economic offences unit extracted paper in para 3 and so, which and so, they have read that judgment in some other context. My Lord has read it. And this is the view of the Commission. In that case, although it was dismissed on the ground of no custom etc. But this is the situation, and this is the stand they have taken. The fact is there, despite all instructions, mobile phones were inside. And all, these are all possible. Therefore, I say inquiry was a must. It's all possibility he is there. Merely the law is there, 302 is there. It doesn't mean murder does not happen. Murder took place. You could violate the law. In examination center, law has been violated according to us. So it had onerous duty on the Commission to want an independent body, get it examined. You are not that you have kept same person. After 1 month, you are asking report to the examination. So, these are the submission law. The one case they may rely this one. One side Jadhav case that neat matter, no? If he does not rely, then I thank him. No. But then a distinguishing picture.
What do you want to say in that judgment?
No?
What do you want to say for that judgment?
This judgment, has not allowed.
That we know. The examination was not cancelled.
Yes.
The law with respect to cancellation of examination was reiterated there.
Reiterated, but there are leaks. It says if there is material to suggest that leaking has done affected.
It also says that no strict proof is necessary.
Yes. So therefore, this judgment to large extent.
इसलिए मैं कह रहा था कि आपने कैसे समझ लिया कि वो रिलाई करेंगे? They may not use it to their advantage.
Double way movement. उनके खिलाफ भी है.
इसीलिए तो कहा.
So they were required to, and then many people have said, which I'm arguing, that the whole episode is violating of Article 15 and 16, and therefore my Lord made it okay. It affects the recruitment process. It affects the conduct is arbitrary. Therefore, violating of Article 16. It affects the recruitment process illegal and then being done illegal. They also violate Article 16. So these are my overall solutions.
Yes, next. Who appears in the other matter? Next one. Who appears for Ajit Kumar?
Some aspect has been get.
Your Lordship, please, my lord.
Ajit Kumar.
No, this is my lord Prashant Shekhar.
Who appears in Ajit? Chandan Kumar Mohammad Fazle Kareem. All right. Nobody appears. Prashant Shekhar only. Yes. Yes.
My lord, the facts of the case, my lord, they have already been narrated, my lord. The issue is as to whether or not, in absence of rules permitting, my lord, Bihar Public Service Commission to hold the examination on 2 different dates. The preliminary test, which is primarily, my lord, in the form of an elimination round, in order to enable the candidates to participate in the main examination, and those who succeed, my lord, they are shortlisted for participating in the interview, and on that basis, my lord, recommendations are made for appointment in different services of the state government, as per the advertisement, my lord. Now, the issues involved in the present writ application, my lord, I would, of course, since I have not stated anything about the large-scale illegalities and failure on the part of the authorities and the commission, my lord, to comply with the SOP and the rest of the things, that is not a part of the pleadings. Our case primarily is on 1 point, my lord, 2 points, my lord. First, that conducting preliminary test on 2 different dates, my lord, in absence of rules permitting the same, my lord, whether or not that is violative of Article 16 and also, my lord, Article 14.
And on 2 dates, you mean to say that the retest of which was taken?
My lord, yes. 2 different sets, candidates having been segregated, my lord, and 2 different sets of candidates were there. The candidature was divided. And then, my lord, on 1 date, there was 1 set of question papers on the basis of which evaluation of performance of candidates was carried out. And then another set, my lord, of course, a smaller pool of candidates, but they have been given another opportunity, my lord, in respect of the same examination, whether or not that was permissible, and whether or not, my lord, that...
My lordship, in instant petition 1IA is pending, my lordship, to add me as a petitioner.
Please take your seat, listen to his arguments. Without adding you, we will hear you for a minute, but don't stand in between, don't disturb the court proceeding. Sit somewhere, find out a seat for yourself.
My lord, I'm sorry, come on.
Please listen to the arguments, and then whatever you have to say, you will say. We have not ousted you from the proceedings. Take your seat. Yes.
There will be a little bit of repetition, my lord. So it is, my lord, a case where once, my lord, they themselves have come out with this clear-cut notification that there will be only 1 preliminary test. In that event, my lord, on account of the lashes on their part or failure on their part to conduct the examination in a fair manner, whether or not the candidates could be segregated, following, my lord, whatever methodology that has been adopted by them, I would not be...
Mr. Srivastava, though we have given patient hearing to all others, we will not put you to question, but we are not...
I won't take too long, my lord.
No, we are not understanding your submission.
My submission, my lord, is that the preliminary test...
All right, so preliminary test, one
had to be 1.
Just a minute, preliminary test took place when? What is the date? 31, sometimes in December 2020.
My lord, yes.
31st of December, right?
13th of December.
Huh? Whichever is the date.
My lord.
Date X in the month of December 2020.
My lord.
Is that correct?
My lord.
Now, thereafter, there was some reporting about
mismanagement or whatever.
Mismanagement. So another test was for few centers. Another test was violated. You're talking about this another test.
I'm talking about both the tests, my lord. That
segregating. I mean,
segregation on the basis of the examination centers, man.
So therefore, there would be no rules contemplating that in case there is mismanagement of a
Therefore,
particular
my lord, whether or not this is permissible on the touchstone of Article 14 and 16, this is what I'm trying to submit.
That's a very novel, ingenious
It is-
argument,
it
but
is-
it doesn't appeal
But
to
my
us
lord,
straight away.
it finds force, my lord, in several judgments of the honorable
Just
court.
show us.
I'll be coming to that, my lord,
No,
after
start
giving
with,
the
start with that. It's
foundational
very,
facts.
it is very interesting for us to hear this. Therefore, we would like you to number it down.
I'd be referring to those, my lord. First, my lord, the facts the way they are, my lord. Now, they say that this is a preliminary test which will be conducted on the basis of the objective test that would be conducted, my lord, and evaluation of candidates on the basis of that one examination. They would be shortlisted to participate in the main examination. Now, the format of the examination, my lord, is clear. It is an objective examination, meaning thereby there are multiple choice questions and you have to tick on the right question, and on that basis it is to be done. The uniformity must be maintained, my lord. And for the purposes of ensuring uniformity, my lord, and to avoid unfair means being resorted to by the candidates, same questions are asked though in different sets. The sequence of the questions are changed so that everybody is subjected to the same degree of, my lord, the
Rigor.
rigor, my
Same
lord.
test.
Same test. So no
You're right.
sooner than there is a
You're right to
subsequent.
that extent. You're absolutely right to that extent. But in case of this unforeseen circumstance where some centers there were reports. Now what could be done? Same questions could not have been repeated.
Not at all, my lord. And therefore,
Therefore-
another test for all.
Therefore you're suggesting that it has to be somewhere. That's
My lord, yes.
shows the judgment. Therefore we said that it's an argument which would take away, which would take away the shine from everybody else's argument. If this succeeds, nothing else is
My
required.
lord, I'd be, my lord.
Let it be
the
your
judgments
point.
are primarily on Article 16, my lord. We'll be coming to that. Please allow me, my lord, to just formulate these
Again,
questions.
you are testing our patience in a different way.
No, we are not.
This we need to
As
be
a matter of fact, my lord, it was not just my lord's patience that was being tried. We had been sufferers ourselves also, my lord. Since morning, we had been listening to quite a few things.
But
which were-
tell me one thing. This is an interesting aspect, and you say that it has the sanction.
My
of the
lord
Supreme
would
Court.
decide that. And I'd be, my lord, referring to the judgments of the courts also. Now, before that, my lord, I'll give a very brief, my lord, historical background. I'm not relying on that judgment, my lord, but the manner in which the laws have evolved. Equal protection, my lord, this entire concept which was introduced in the US Constitution by way of the 14th Amendment, my lord. They came out with another way, my lord, to overreach that. That was called the doctrine of separate but equal. Plessy versus Ferguson case, my lord, 1896. The US Supreme Court, my lord, held that so long as the facilities were of the same standard, separate but equal, that was not in violation of the US Constitution and did not affect in any manner, my lord, adversely the Equal Protection Clause, which was introduced by way of the 14th Amendment. Till the time, my lord, when in the year 1954, by a majority of 9-0, the US Supreme Court in the case, my lord, of Brown versus Board of Education of Topeka overturned that judgment and said that no sooner than the separate is there, it is inherently violative, my lord, of the Equality Clause, Equal Protection Clause. There cannot be two different preliminary test examinations, my lord, because the students...
You are aware the historical context in which these judgments were given. And a basic situation,
It will not apply.
Not in view of something which is akin to Article 16 of Indian Constitution. You know that.
My lord, equal protection has been taken from there, my
Equal
lord.
protection, all right, but it is not in
But the separate is not equal. They can say that on account of the failure on my...
You can't stretch.
My lord, I'll very briefly, my lord,
We are not very happy to hear this argument because the basic premise of Article 14 and equal test and equality test, you would be putting everything to naught.
I'd be relying, my lord, on Article 16.
See, Brown versus the
Board of Education.
Board of Education. See versus.
It was only, my lord, to bring home a very simple point that separate is not equal.
All right.
It is an admitted case, my
Not well
lord.
taken, but nonetheless, you can proceed.
My lord, in this case, they say that there was a failure on our part to conduct the examination in a free and fair manner, in a transparent manner at a few centers. But there is an admission, my lord. They do not say that res ipsa loquitur, my lord. Things speaks. If, my lord, there was no failure, why was the examination held with respect to a certain set of students on the 4th of January? I put that question to myself, my lord.
We have not admitted.
My lord, this is not an admission. It is, my lord, a case which is established.
All right.
What I am submitting for my lord's kind consideration is that on the basis of performance of students in the preliminary test alone, they are to be shortlisted, my lord, to participate in the main examination. If there are two different preliminary tests, which in the first place they profess to be conducting just one, but there was a failure, to conform to the SOP or whatever, my lord, and there was apparent, my lord, failure on the part of the commission to maintain the sanctity and the sanctity alone, my lord, of that examination, my lord. In that event, they decided to conduct another examination. I say, my lord, even if there is one person who has been benefited or who has been subjected to some kind of a disadvantage, my lord, that is in the teeth of Article 16. Now, my lord, Article 16 I may be permitted to place.
Yes.
My lord, if there are two different, my lord has already observed it while the arguments were being advanced, that in order to ensure that there was uniformity and equality, my lord, in relation to the subjective test for the same process of
We
selection.
understand that there could be problem because the question set, the quality of questions in the second examination may have been of,
No, not of
below
lower,
par.
no, I'm not on that, my lord, not
But
on
you know,
qualitative analysis.
on a-
They were different.
on a theoretical basis, they were different.
They were different, my lord.
No, we are only trying, we are only testing your argument at the threshold. We are not stopping you. We are only testing it at the threshold. I mean, can that view be taken here when there is when the settled position of law is that not in, cancelling the entire examination should be the last resort. That's what the Supreme Court says. We are not saying it.
Situation warranted it. That last resort had
So
to be
therefore,
taken as
forget it. Now you can argue that situation was that it should have been, the entire examination should have been
Nonetheless.
Nonetheless, finding fault with holding another examination, especially on the ground that it does not find favor, there are no rules to it, that in case of some mishap.
That is, my lord, doctrine of necessity will take care of. Even if there are no rules, my lord,
That's
they are,
right.
my
So
lord,
we
I will not stretch it that far. I will never go that far, my lord, to say that it is an absurd or an arbitrary action. What I respectfully submit here is only on the touchstone of Article 14 and 16. I am not exceeding that.
The basic ground goes, no, you can argue other things. That, you know,
There are those things are also there.
without the separate examination, without questioning the correctness of the decision of the BPSC to go for
The
second,
separate examination, my lord.
without going for without testing the correctness of that decision, you can say on the basis of what happened on 31st. But can you really question that wisdom? I mean, that had to be done. They could have gone to the extent of scrapping the whole examination. Well and good. Or if they have done this, but this was inadequate. You can say that. But talking it, labeling it as something which is made separate, not equal, different opportunities. I don't think it's acceptable.
I would be.
Again, we from yesterday's
Going by my lord's observations, I believe I'll be testing my lord's patience a little bit more.
Yesterday's argument in a different context, you know, the entry point is very difficult. Once you make that foray, then perhaps I also start contributing. But to enter that field, it's very difficult.
Yesterday's experience, my lord, teaches me it is difficult, but we ultimately succeed, my lord. So I would not be giving up on this, my lord.
All right, now we have told you our initial response
My
to
lord,
your first
what I am
argument.
submitting, my lord, is not questioning their wisdom. What I am respectfully submitting here, my lord, is the scheme of this process of selection may kindly be appreciated. Now it emanates, my lord, from Article 16. I may be permitted, my lord. They have given examples of admission into educational institutions.
It is
Public employment. It has been created. It is a different
And
class.
most of the judgments, when they talk about employment, they also talk with a slash entry into
Some of the
institution. All cases.
I would, my lord,
5 or 6 which are quoted every time, they rate it at equal level.
my lord, in
They say that only after obtaining that degree you go for examination, and that's how your talent is tested. It was never discussed.
Well.
But everywhere where I have gone through the judgment, it says admission to particular institution / procuring appointment.
It is not my intention, my lord, to instantly contradict my lords with some examples, but my lord will appreciate that in cases of admissions and PG courses in
Anyway, that's different. So they have taken an example.
that, my lord, that has been completely denied in cases of public employment, where they said institutional preference will be given in matters of admission. That thing was outrightly, my lord, denied in matters of public employment. No institutional preference.
That's why public employment is something else.
Because Article 16, my lord, it is a separate set. You're right, my lord.
It cannot be similar. We just said taking admission in a
Of course, my lord, courts have followed by and large
That's-
same principle.
That's for the benefit of of the individual. It's not for the benefit of the institution as such.
Not at all.
For the benefit of the individual. Public employment, apart from the individual's benefit,
It is the state
the
manner.
talent, the state which
Manner,
benefits.
manner.
Good administration. Therefore, but the standard, the test standard is the same.
Almost the same.
Yeah.
It is the common thread.
So therefore, even that, you have to see, it is a. Well, you're not making a foray into this field instantaneously. That's the reason why we are putting you to questions. I can proceed.
We'd need more modest manner. After that, perhaps the rampart would be somewhere. We'd find a chink somewhere and we just try to make an entry there. Article 16, my lord. I'm really sorry, my lord, for placing these fundamental things, but it is important, my lord, for the purpose of identification of the issues.
Ultimately, you come down to these fundamentals only.
From the most sacrosanct part of the constitution, my lord, arguments with respect to malpractices, etc. In my humble submission before this honorable court, my lord, for want of pleadings, we are not relying on that. However, I believe that a stronger case will be a case where we are able to demonstrate infraction of the constitutional provisions. And that was why, my lord, I started off with equal protection and violation of Article 16. Now, Article 14, my lord, the way it has been worded, we kindly wish to know. It is, my lord, that one small dictum that takes care of majority of the things. There is no free lunch. After having carried out, my lord, several exercises of deciding one line law that would ensure public good and welfare of all, something to be conveyed to the citizens, my lord. The king directed for somebody to come out with, that one line. After exercise that went on for several years, my lord, this one line came out. There is no free lunch. We have to make our own contributions in our own little way, and then alone, my lord, we get something. Article 14 is a classic example, my lord. Article 21 and Article 14. This is just a two-line thing, pregnant with meanings unlimited, my lord. The kind of interpretations over a period of time through judicial pronouncement, my lord, we have come across. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Similarly situated are to be treated in an alike manner. There is no greater law, my lord, than this. In a process of selection, my lord, that flows from, my lord, Article 16, which once again, my lord, reinforces the same principle but in a slightly different manner, and that ensures that there is absolutely no scope left for any kind of a miscarriage. Furthermore, my lord, fortifies using expressions like equality of opportunity in matters of public employment. There shall be equality of opportunity, my lord, for all citizens in matters relating to employment or appointment to any office under the state. The Honorable Supreme Court and, of course, my lords have gone on to declare it to be public wealth, public employment in a country of the present kind, the democracy that we are living in, my lord. This is the only avenue, perhaps, for millions of our own citizens, members of our citizenry, my lord. In a situation of this kind, whether or not, my lord, any infraction or a deviation from the written law is permissible, or the manner in which the processes of selection are to be carried out, my lord, whether or not this kind of a deviation is allowed. In O. Chakradhar versus Union of India, my lord, the Honorable Supreme Court, we have furnished the list of dates. My lord, the Honorable Supreme Court had declined even to enter into the area to segregate those who could have wrongly benefited and those who could have been disadvantaged. On the ground that it becomes so difficult to separate, my lord, those who had been wrongly benefited from those who had not been wronged or who had not derived any benefits out of such erroneous or illegalities committed in the process of selection, my lord. The entire process of selection was scrapped. We are still at a preliminary stage, my lord. There, the entire process of selection was set aside by the orders of the Honorable Supreme Court. And they were directed, my lord, to carry it out strictly in accordance with law. Now, there is a recent judgment also, my lord, of the Honorable Supreme Court, where the Honorable Court has held that if the process of selection is suffered from an illegality at the nascent stage itself, then irrespective of the fact that for years together or 10 years or more persons have continued, yes, my lord, they cannot be removed. And the process of selection have been set aside. Where they had culminated into final appointments, my lord, it has been done. We are still at a preliminary stage. Now, no sooner than, my lord, it is not a case of the fence sitters who are waiting for their fate to be decided on the basis of the results as were to be announced or otherwise. No sooner than, my lord,
you have made that point of Article 16 and Article 14. Now, tell me one thing, what is it leading to? That there should be one exam. There should have been one exam. Also.
Now, second, I have not.
You're not done with it.
I'll be coming as in. There is another important aspect, my lord. When the entire evaluation is on the basis of erroneous model answers, we have not only given the instances, my lord, of it, but we have supported it. We have given the supporting documents also to demonstrate how the evaluation has been done on the basis of erroneous model answers. It goes to the root of the matter.
That's a ground which we will be.
And my lord, the commission has chosen not to advert to any of that.
We'll be welcoming that argument.
But my lord, Article 16, it is difficult, my lord, but this is
Anyway,
the most
that
important argument.
depends on the constitution of the bench. I mean, this Article 16 argument is absolutely, there is an impervious layer which does not allow it to go. What about marginalized students
My lord, in a
who
case,
cannot afford a second time examination? About who?
my lord, yes, this is not a compartmental examination. My lord must appreciate it.
Anyway, you have a better ground. I mean,
My lord, I'll give a bad example, my lord. But
don't
it
give
is
a bad,
bad example only to bring home a very simple point.
You keep this argument for the last. Otherwise, the difficulty would be that I will every time you are interjecting. You start with that.
My lord, I'll be
Questions,
coming.
evaluation and all that.
My lord, why I was making that submission was
We will not stop you. You have a right to argue. We will hear you on this, no matter how much
sequence, my lord.
resentment of the bench is to this ground for the reason of its untenability in our.
sustainability, my lord, to be.
Yes. Ultimately, it has to appeal to the court.
Of course, my lord.
So therefore, keep it for the last. That argument. We are being very candid, and in fact, I need not have.
My
been
lord, this is the main case that
I need not have been so honest in telling you that this argument is not cutting at all. No ice is being cut in with this argument. So instead of wasting our energy on this argument, shutting
My
you
lord,
out from
I
that,
had almost reached there, my lord, but then my
you
lord,
had almost reached there. 10 minutes.
10 minutes for this.
Yes.
My lord. Equal protection, my lord, I have placed. Equality of opportunity in matters of public employment, my lord. The wordings of Article 16(1), there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Now, what would the expression opportunity mean here? Whether or not it would mean only to allow everybody to apply, or equality of opportunity would also mean when they are subjected to the same rigors of the examination. Opportunity, my lord, is an important expression.
Same rigors, yes.
Same rigors.
There could be compromise on that with second examination in various ways. Somebody getting more time to get ready. One who had not prepared well that time, he could prepare himself. Number three, the quality, the below par, above par questions also would matter. And another chance is always better. You are experienced. You're right. That test of rigor,
My lord, yes.
gets compromised with another test. You're absolutely right. But could this principle be imported for saying that never, don't take this examination. Don't segregate. Don't segregate the centers. Don't segregate candidates. Can it be said? I mean, that's
Why it should be said, my lord?
who disputes that the standard of rigor should be the same? And therefore, the policy of testing everybody with the same set of questions, though in different sequence. Nobody disputes it. That's what we are trying to tell you. We are not telling you anything against passive versus progression of board of education. What we are telling you is that we understand that, but what is the way out? Because the consistent rule is that examination, I mean, segregated compartmental examination or different examination for few centers, that is the rule of the day. Every judgment would tell you that it should not be, the scrapping just out of the hat is not permissible. So this argument initially has faced this, I mean,
Judgment, my lord, that recently came.
Test rigors, we understand. Every time you argue a case second time before this court, you will find yourself to be more equipped because you know the mindset of the
My
judge.
lord, yes.
You come back tomorrow with the same level of your understanding, same level of the understanding of the bench, you will find it more convenient to handle this court. Why? Because of the passage of time, because of the time that you get for further preparation, and because of your understanding of the way in which this judge is thinking, right? So therefore, the standard of rigor does change. But let me tell you again, just to bolster up. I mean, this is not to sort of keep you away from that argument. You know, when basic structured doctrine was being argued, you know that. Mr. Palkiwala did not have any document except for one stray article written by a German author. And he went into the courtroom with only that article and he built up on that. So we will not stop you from building up this argument. Right? But keep
My argument, my lord, was limited just to that.
Keep it for the last.
What would it be? What is equality in matters in equal opportunity, man?
If they follow that. So the same
My lord,
test-
the expressions that I
so
am
therefore,
using, man.
therefore, if we understand you well, reading 14 and 16 together, the standard test of standardization of the rigors which candidates have to pass
It has to be
will
same.
get heavily compromised by another
Deeply
examination.
organized.
That's the
I could not have put it in a better way, my lord, but
No.
I'm borrowing my lord's
This is-
expressions. This is what we are trying.
this is what
My
this
lord,
is what
yes.
we have.
But I should come to it later.
No, I do not say no to this, but I do not find any other obvious, road. That's the difficulty. The rigor gets
My
compromised.
lord, it has been compromised.
Yeah.
It has been compromised.
True.
Now, my lord,
True.
What-
No, if not for anything, for the passage of time, for preparation,
My lord,
for
yes.
the adding of experience.
additionally, my lord, there are several other factors, my lord, that also count. We are not going to recount all those factors. And then,
Your argument to that extent has been understood by us. Now you can build upon this. वो आर्टिकल 16, 14 अभी छोड़ दीजिए, उसके बाद बढ़ाइए।
other वही opportunity के लिए हम 60 और there was no other.
वो समझ गए। टेस्ट की स्टैंडर्ड टेस्टिंग जो है वो कॉम्प्रोमाइज हो
My
गया।
lord. So that thing, my lord, it has been compromised.
एक बात बताइए। I want this question to be answered for my satisfaction, not for this case.
My lord.
Now, examination system somebody could rate it as the only system for screening people for search of talent. Somebody biggest pass. Is there any way? Is there any other way?
We try our best, my lord. There is no way to
There is no
ensure.
other. There is no other way
We
except,
try our best.
except testing the candidate in an
Right.
examination like schedule.
A common, a
Is it,
uniform
is, it,
test.
is it a test of talent?
No, it is not.
We are not on this. We are on the question of averaging of the standard.
It is not, my lord.
It is
This
not.
is not the best way.
So therefore, let me put to you another example, just to test this proposition that you have given. Now, I also feel it this way, that if my examination paper, if my answer sheet would have been examined by Mr. Abhinav Srivastava, perhaps I will get 8 marks. If it is examined by Mr. Giri, he will give me 4. Is there any standardization?
Not at all.
So, forget about this.
This is all vagaries of examination.
Multiple choice
We are-
question,
we are-
all right, we understand. But can there be an equal score if we limit it to this? That's why the initial resistance to.
And that was the only reason perhaps the reason, my lord, why I was making this submission, because it is not with respect to subjective valuation. In an objective examination, unlike all other modes of tests, this can be ensured because everybody is subjected to same set,
Yes.
not similar, my lord, or identical, same.
Yes.
And that's why, my lord, equal opportunity would
You're
mean
right.
same and not identical.
Therefore, I was making this example saying that I am not on the facts of this case.
Generally, my lord, yes.
Multiple choice question, of course.
My lord. And why so? Although I'm not, my lord, in a position to attribute too much of wisdom to any of the agencies, but my lord, I can say this with a sense of confidence that they ensured it at least at the level of elimination, the election, because we will be denied the opportunity to be considered for appointment on the basis of this. So saying that this is a mere elimination, my lord, it cannot be taken so casually. The counter affidavit that has been filed by the commission, my lord, and a copy of which we have received, it's a case of, my lord, semantic hair splitting, taking words and elaborating on that. We say that it was not the same test. They have not answered that. Since it was failed, therefore it is done. Can that be permitted to be done? Is that permissible, my lord? And heavens will not fall. We have had the entire examination scrapped after the appointments have been finalized.
Yeah.
There are one too many examples, my lord.
In the state of Bihar,
In the state of Bihar only, my lord.
in our judicial examination. Now we have done that.
My lord, it has to
And
be
only
done.
the only question of, only on the question of 5 of the answers having been found to be wrong, decided by us. We decided against the High Court. And another set of examination was held. We are aware of this. After all, it's entry level examination now. Therefore, we are telling you that argument you cannot take further. We are appreciative of your argument, but yeah, this is.
My lord, what is the solution? I believe, my lord.
I asked from you, what is the solution?
My lord, I believe this is the question that my lord is putting to me. What is the solution?
Yes.
It's very simple, my lord. Entire thing to be scrapped and a fresh examination be taken. That has been done. My lord, lords, my lord. It was the established principle. Fiat justicia ruat calum, my lord.
नहीं सब कह रहा है थोड़ी हमको पास करा दी अब वही रहा है कि हमको री एग्जामिनेशन कर दीजिए जब तक हम पास नहीं करेंगे हमारा क्या है कि एक बार हम कह रहे हैं कि री एग्जामिनेशन करके हमको पास कर
मौका दीजिए
मौका नहीं कर रही तो लोग समझ रहा है कि हम मैनुअल मांग रहे हैं डिक्लेयर्ड एज ए पास दैट्स नॉट द केस वी वांट टू अगेन बी टेस्टेड of your by your scale whatever it is तो इसमें इतना रेसिस्टेंस का क्या बात हो रहा है भाई हम तो रहते थे तुरंत कर देते हैं तो
एग्जामिनर नहीं एग्जाम होता ही नहीं आप वैसे हजूर हम कह तो वही रहे हैं if we are able to demonstrate कि ऐसा कुछ गलती हो गया है, the best way to handle the situation, my lord, is to undo the entire wrong, reconduct the exam. We are at a preliminary stage, my lord. The government has all the wherewithals. They have been conducting this examination on a yearly basis, my lord, and sometimes 5 times in a year. BPSC is a constitutional body, my lord. They have been, and then I would not be touching the constitution for the present, my lord, but there are constitutional body which are deciding constitutional this stage, and my lord have given missionaries example yesterday. A 1 centimeter here, my lord, after 10 feet, it is, my lord, a lot of difference. We cannot allow this to happen, and this is an ongoing story right since ever, my lord, ever since it became transparent and people started raising their voices against it. We cannot compromise on the quality of public employment at this stage. It cannot be done. In matters of admission of students, my lord, that is all fine. They are by and large, my lord, on the same plane. But here, my lord, these are no more students. This is this is an opportunity, my lord, that decides not only their career but also, my lord, Article 21, the right to life, right to live in a particular way, my lord. Chhattisgarh High Court has directed for it. Similar circumstances, my lord, and we are only at a nascent stage. It can be nipped in the bud, my lord. If we are at a nascent stage, my lord, this is the time when it should be done. If it was after the main...
Mr. Giri had cited Chhattisgarh judgment saying that this is the only judgment that he could find.
No, sir, Abu judgment. There are more judgments
that he could find. There are so many of this High Court only.
My lord, yes. My lords have passed the orders, my lord. They are beneficiaries of my lord, yes.
By us.
My lord. One question, which may be decided either way, my lord.
Yeah.
Is it same opportunity? It is not. Yeah. My lord, I have most respect.
You know, this proposition again, I am repeating.
My lord.
I am again repeating. This proposition is not cutting ice. This is not being appreciated by one of us. I don't know about my brother.
But my lord, sometimes the argument which we are trying to make before this honorable court, my lord, is that the rigors get affected, my lord, and therefore it does not remain equal opportunity.
I've told you, again it will be repeating the same thing in another set of words. Every time that a second chance is given to...
My lord, it causes advantage and disadvantage. Therefore, my lord, what we respectfully submit, we are not even going into, my lord, the aspects with, although we have, my lord, I will be coming to that. But this, my lord, this is...
All right, so this argument we have heard, we have heard. any judgment that you wish to give, you can give it later.
My lord, exactly.
We have understood. I think you should be satisfied that we have understood your argument. 14 and 16 and a second, a standard of rigor has been lessened for new set of students. All right. And therefore, public employment, it should be considered. It should be, I mean, one should think 5 times over before giving this kind
My
of.
lord, it cannot be because
We have understood it. We have expressed this only for your confidence that you proceed further, not that it has not been understood. You must know
Nevertheless,
this.
my lord, we will persevere, and I'm sure, my lord, at the end of it, my lord would be.
You must know what is passing on your mind. Because if we don't speak our mind, perhaps you'll think and you will be, you'll be in the dark.
But all what I was trying to convey to my
But
lord
you-
was
you
that
conveyed
there has been a failure on the part of the commission. Now the commission is
No doubts unless we hear them up till now. No doubts.
without hearing my
Where was the where was the question of ask? Anyway, we will discuss that later. But you argue the other aspect.
my lord. The other aspect, my lord, will be first that it was the thing that I'm not going to repeat now, my lord. The second aspect of it, that the commission under these exigencies or whatever circumstances that prevail, this was the only option which could be given a legal sanction for reasons beyond their control or discretion. There is no lack of bona fide and the rest of the things, my lord. Even in that event, my lord, the evaluation at least had to be carried out in a free and a fair manner. Now, the evaluation had been carried out on the basis of the model answers which were published by them, in respect of which, my lord, objections were submitted. And there we sought to demonstrate by way of referring to the authority or the textbooks, my lord, on those points, but they have not considered that. My lord, where is that? My lord, we have demonstrated annexure P13 series, my lord, page 279.
279.
279.
Yes.
My lord. Annexure P13.
Which page?
My lord, by way of this press note, my lord, page 279. I may be permitted to this was published on 8/1/25. 8 January, my lord. संयुक्त प्राथमिक प्रतियोगिता परीक्षा का आयोजन राज्य के 911 परीक्षा केंद्रों पर हुआ। अच्छा सर, एकीकृत 70वीं संयुक्त प्राथमिक प्रतियोगिता परीक्षा का आयोजन राज्य के 911 परीक्षा केंद्रों पर दिनांक 13/12/2024 को शांतिपूर्ण एवं सफलतापूर्वक संपन्न किया गया। आई एम वेरी सॉरी माय लॉर्ड, दिस इज अ वेरी सीरियस मैटर, बट आई मस्ट अप्रिशिएट द सेंस of humor that commission has. Shantipoorn and Safaltapurvak, and the protest, my lord, continue to have. Shanti bal lathi chal raha hai, Shanti, my lord, during the course of that examination, my lord, the protest started. हम लोग क्रिकेट खेलने थोड़ी जाते हैं. We win. Our players, they play the matches and we win. India wins, my lord. My lord.
एक तो हमारे में तो नहीं, वो भी आपका एग्जामिनेशन के पहले की
आपका
पहले की घटना है।
13-12 के पहले आपको कैसे लाठीचार्ज हो गया?
एक आदमी
तो परीक्षा भी नहीं हुआ।
नहीं
All right. Yes,
my lord. शांतिपूर्ण एवं सफलतापूर्वक संपन्न किया गया। बापू परीक्षा परिसर केंद्र की पुनर्परीक्षा भी दिनांक 4/1/25 को इस परीक्षा केंद्रों पर शांतिपूर्ण एवं सफलतापूर्वक संपन्न की। करते हुए अभ्यर्थियों से दावा आपत्ति की मांग दिनांक 16/1/25 तक की गई है। विषय विशेषज्ञों की समिति द्वारा अभ्यर्थियों का दावा आपत्ति के निष्पादन के बाद निर्धारित प्रक्रिया अनुसार अंतिम आदर्श कुंजी प्रदर्शित की जाएगी।
वो भी है, नीचे वाला नोट इज इम्पोर्टेंट।
माय लॉर्ड, प्रश्न convenience, my lord. Page 351.
Yes.
convenience, my lord. Page 351. The question, my lord, is in the middle, my lord. Too high. According to the commission, my lord, the official answer, my lord, is option A. Answer should be none, which is also an option, my lord. For the reason, my lord, that we have brought this on record, proof the struggle of my life, autobiography of Swami Sahajanand Saraswati, my lord, a periodical that was being issued. It is not a newspaper. There is a difference between that, my lord.
But that was named Lok Sangra.
My lord. Now, the answer is that Lok Sangrah, it was not a newspaper. It was a magazine. Although it is, my lord, taking a very fine distinction, my lord, however, it is incorrect. It is incorrect.
If
The E, my lord. I'll just place that, my lord, from the answer.
no, but you have given only four options.
Four options are there, my lord. But
Where would he tick in none of the above? I can't be, no? None of the above is an answer where they want to test. Available for all. Yes, next. We have followed. It's a Lok Sangra is a magazine, not a newspaper. Okay.
my lord.
Then,
The next one, my lord, is we have also brought this on record, my lord, the proof. Now the next question, page 353, my lord. Size.
yes. Yes.
My lord, according to the commission, they have treated bauxite to be the correct option, my lord. Whereas pyrite also, my lord, is an iron ore. And in support of this, therefore, it has more than one correct name.
Which source do you say?
My lord. The following page, NCERT, my lord. At the bottom, my lord, would find page 353 itself.
Yes.
And it is the relevant excerpt from there. My principal ores. In the middle, my lord, would find the chart, the table, my lord. Table 6.1, principal ore. Aluminium, my lord, is bauxite, by the way. They are treating that to be the correct option. There are one too many judgments, my lord, on this, that a committee can be constituted and the correctness of these things are to be examined. I would try to create that doubt.
We know that. Let's perhaps reach our